I guess their exams in a week, so they're panicked. Thank you all for coming. You don't want to hear me. We're here to hear Jennifer Costello talk to us about the regulation of lawyers and compliance. So I'll get out of the way and let her tell us about lawyers and regulatory compliance.
Thank you so much. And first I just want to say hello to everyone and thank you for the warm welcome that I've received so far. I've really been enjoying my time between last night and this morning, and I look forward to speaking with more of you for the rest of the day. So thank you again for the invitation to come. So in this paper, I'm going to be discussing the significant influx of lawyers into the compliance function in recent years, so specifically either serving as compliance officers or working within compliance departments, and actually propose a framework for how lawyers in sort of what we could call these quasi-legal roles, where there's very much a fine line between a business and a legal function, how they should be regulated in light of their professional obligations. Because as it stands, in which compliance is really currently an unregulated field, especially as it pertains to joint lawyers, compliance officers, I argue there's a greater potential for personal liability for sort of unknowingly violating ethical rules in the course of their compliance work. So just to kind of start off as background information, as we're all aware, we're living in an era heavily defined by extensive regulation. This applies to industries of all types. It's really led to compliance becoming its own distinct discipline, and has sparked, a boom in the amount of jobs that are available in the compliance function as well. There's been a significant influx of lawyers into this role. Some of that stems from a little bit, the aftermath of the financial crisis, maybe a general decline in traditional law practice jobs. But also it's been noted the lawyer skill set is really a great fit for compliance as a whole as well, because it's centered around thinking about an organization adhering to regulations, interpreting laws, offering advice, thinking about how regulators and courts, would manage issues. So it's really come to be known in the field of compliance as a JD advantage job, right? Where a JD is not required, but it's certainly preferred if somebody enters into a compliance officer position with that in hand. Okay. And so in thinking about kind of where lawyers fall in compliance as a whole, I think it's fair to say in recent years there's been more of a modern move away from kind of the traditional zealous advocate model where, as we all know, consists of undivided loyalty to a client, a completely client-centered focus, and is very precise and a good fit for adversarial litigation-based practices. But more and more in recent decades, we see a move towards the gatekeeping function, where a lawyer has, more of a public interest role and is doing things like raising red flags, working on kind of preventative measures so that large-scale problems, do not escalate and result in litigation and things like that. And pursuant to the Sarbanes-Oxley Act of 2003, lawyers now have, when they represent issuer clients, kind of the organization, they have essentially up-the-ladder reporting duties to report to the board of directors any material evidence of violations of the law that they may see happening. If they have more of an opportunity to utilize a permissive disclosure to inform the SEC of this kind of stuff. And the Model Rule of Professional Conduct 1.13, when you're representing an organization as a client, has really mirrored a lot of this sort of internal reporting, I like to think of it as almost like an internal whistleblower type of scenario that more and more lawyers have today. And all of this is really conducive to raising red flags, self-reporting, self-regulation. All of that is a good fit for describing the compliance function. But despite, the significant influx of lawyers into these positions, there really has been almost no response from just the organized bar in terms of regulation of such individuals. The model rules themselves, currently, they don't address, compliance rules specifically. And last year, the ABA published a desk book that it called a first-line consultation resource for compliance professionals to help them understand the regulatory space in which they're operating. And in having read that book, I can say that it really is a substance-rich kind of summary of, here's a chapter on anti-money laundering regs, here's one on the regs in IT, one on financial, but nowhere does it really address any of their ethical obligations in how they would conduct themselves in compliance with the rules that might be incumbent upon them. So in order to kind of think about how individuals in this space should be regulated, a threshold question is, can you define compliance as the practice of law, right? And this really has come up because in reviewing various surveys and interviews and studies, it has turned out to be the case in a lot of instances that in an organization, the constituents, when they're interacting with someone who has the title of lawyer, whether they're practicing law or not, or in an attorney-client relationship, tends to lead constituents to believe that there is an attorney-client relationship present there, in their conversations, which of course could be potentially problematic. And then if you look to the model rules of professional conduct to ask, how do you define the practice of law, you won't find the definition there at all, right? It's going to defer the matter completely to the 50 states. And in looking at, I looked at all those different state definitions, they're very vague, right? They purposely avoid coming up with one definition and are very fact-specific. But if you pull kind of common themes from all of them, they tend to have roots in really sort of adjudicated elements, right? Like appearing as an advocate, drawing up papers or pleadings on behalf of a client, providing some type of redress for a lack of rights scenario that could have happened. So it's a very litigation-based, again, approach, and really most appropriate for sort of tribunal-like settings, which does not, the compliance function really doesn't fit squarely within that definition. So it's reasonable to argue that it's not the practice of law, which is what we might have expected. And so in this paper, I place it within the context of thinking about compliance as a law-related service, okay? It turns out that we have a model rule on the books already, Rule 5.7, which governs law-related services. So I'm going to be referring to this rule even in subsequent slides, so I have a handout for everyone of just a copy of the rule. So I'll pass that around so that you can refer to it as we go forward. Oh, thanks. Yep. And I have extras in case anyone doesn't get one. And so, I know, I did feel very productive.
Have you memorized it?
Only you do.
Yes,
We must include it.
So yeah, everyone will get that handed around. And as you can see, and let me know if you need extras. Okay. I sort of highlighted and underlined some key points to this rule. But what it's saying is that a lawyer is going to be held to the full spectrum of professional conduct rules, even if they're rendering non-legal law-related services, in a couple different instances. So that would apply if those services are not distinct from their legal services, or it says in circumstances by an entity controlled by the lawyer, if they fail to take reasonable measures to assure that the recipient knows, there's no attorney-client relationship there. And then here we have the definition of law-related services, which I'll get to in a moment here. But before we kind of unpack this, I just want to say the background behind this rule was to govern the behavior of lawyers who were engaged in ancillary businesses or multidisciplinary practices. So I'm thinking about they've set up shop with non-lawyers, right? Maybe sort of with accountants, social workers, other professionals. And it was intended to hold lawyers to all of their ethical rules. If a client in that setting failed to understand that there was no attorney-client relationship. So as you can see, subsection 1 would hold lawyers to all of the various ethical rules if their legal and non-legal services are so indistinguishable from each other that you wouldn't be able to say this is business, this is law. In the paper, I argue this is justifiable when you have a scenario where it's, for example, like a joint general counsel compliance officer situation where you have kind of a dual hat role. In those instances, it's more likely that the lines would be very blurred between what is legal advice, what's business advice. And so the default is sort of holding lawyers to all of those rules. Subsection 2 is much broader, okay? And the word entity is here, but this is one of my amendments I propose. The modern interpretation of this is that it doesn't just apply to entity practices, it applies to all situations that don't incorporate one. And so what it's saying here is that it does provide an out, I kind of call it an out in the paper, that lawyers can seek to avoid in their non-legal services being held to all the rules if they take these reasonable measures, right, to let the recipient know there's no attorney-client relationship there. This rule has been adopted in all but 15 states. Ohio has adopted it and has made some, I think, good variations to it, which is part of what I base amendments on, that I'll get to a little later. But most of the states that adopted it have taken it on verbatim in this way. Okay. And as we might expect from just taking a look at this, when a lawyer who is not practicing law and operating in a compliance function becomes held to all the various rules of professional conduct, unique personal liability considerations apply in those circumstances. And I'll get to those just next. Okay. So in general, there's really kind of a tension between legal and compliance functions. As we're all aware, in society and professional culture, lawyers are very much trusted, revered confidants. There's a huge level of trust there. That's likely to contrast, right, with the kind of the fundamental role of a compliance officer whose duties are really focused on neutral fact-finding, preventing and detecting any misconduct, and ensuring that kind of all the stakeholders are represented here. So there's kind of an inherent difference between a compliance officer and general counsel pertaining to the relationship that each of those people has with the organization itself. I argue in the paper, compliance officer could be said to be really representing the regulator, as opposed to kind of the organization that's monitoring. And so there's several examples of various rules of professional conduct that when they're applied to a compliance context, they become a little bit problematic, okay, specifically relating to confidentiality, to conflicts of interest. And so as we know, we've got Model Rule 1.6, the duty of confidentiality, very, very sacred rule. In the context of compliance, the lawyer who's also a compliance officer would have to be very mindful of, the limitations of the rule with respect to their duties that they have to report information to regulators. If this were to apply to compliance work, they'd have to be careful to argue that it would fit one of the exceptions that would allow reporting. And that's very unlikely to be the case when the report is really being made, as is so often the case, preemptively in some very early phase to address a problem that's emerging as a red flag. It's actually to the benefit of entities to inform regulators of problems in that stage, because it very much leads to potential cooperation credit, down the road. So compliance officers would have to be mindful of that. It also stands to be problematic for the various conflict of interest rules that we find in the model rules. One of these has to do with the fact that the compensation of a compliance officer a lot of the times is based on the business line's fundamental financial performance. So that could possibly threaten the independence of that individual in this role. In addition, their reporting line might pose a conflict of interest concern as well. It's commonly argued that it's the board of directors that should have oversight over a compliance officer with respect to various things: their hiring, their everyday operations, their termination, and that the compliance officer should report directly to the board. But in many instances, it actually comes down to the fact that it's the executive officers themselves that have this oversight. And those individuals might end up having interests, of course, that are adverse to the organization as a whole. And there's been plenty of cases, in line with all of my whistleblowing research and interests, of compliance officers risking job security and being retaliated against for sort of bypassing internal reporting norms. So what I'm proposing in this paper is amendments to this rule, because I think it's really just a matter of time before this rule is applied to the compliance context. Because It has been a fairly active enforcement mechanism by various bars and jurisdictions. And what I would propose here is instituting a preventative disclosure obligation that looks a lot like the versions that New York, Pennsylvania, and Ohio have adopted to their rule. And so the New York, I'll start with talking about New York briefly. The subsection 2 of the New York rule is really the out that's available there, where a lawyer can avoid being held to all the rules, is really based on client interpretation rather than some directive of the lawyer. So it's broader than the model rule that you see on your handout. It says that a lawyer or a law firm is subject to all the rules if the recipient could reasonably believe that there's an attorney-client relationship there. And Pennsylvania does the same. So you're kind of putting yourself in the mind of the client. It's very different from the model rule, which says if the lawyer fails to take reasonable measures, they're sort of excused from these rules. Both New York and Pennsylvania, they focus on the actual the perception of the recipient, rather than imposing some kind of action on an attorney that ultimately might not be successful in getting themselves sort of out of being held to this rule. Also, New York and Pennsylvania have made clear that what it looks like an entity limitation in subsection 2 is not limited to entities. They've actually listed out individual lawyers as being able to utilize the out option, which is a much better way to handle it and would be effective for a compliance officer who's really considered to be, in many instances, an employee of the firm as well. And this has already been made clear by House of Delegates Ethics 2000 Commission, which said subsection 2 is really intended to apply in all instances in which subsection 1 would not be applicable. So the entity reference really is at this point an oversight as well. New York also requires that this be in writing. The reasonable measures are in writing. That's much clearer than the model rule 2. The model rule doesn't define what constitutes a reasonable measure. It says that it will depend, in the comments it says, that's going to depend on how sophisticated the client is. And that leaves, broad potential for confusion too, because with the differing nature of the constituents, you've got maybe lower level employees, managers, board of directors, they would all arguably have different levels of sophistication there. And what Ohio does, and some of you I'm sure are aware of this too, lawyers who are operating businesses that provide law-related services and not just legal services have a requirement to inform clients in advance that they're not obligated to then seek out legal services from within that same business. They could go elsewhere if they decide, so that they don't feel constrained to sort of stick with that one lawyer. So to kind of sum up, these 3 states they all have a form of affirmative disclosure obligation that's done in advance that helps to make clear what's expected. So I propose reforms based off this, and then just pulling from Model Rule 1.13, when a lawyer represents an organization as client. In that setting too, you're interacting with people who might have interests that are adverse to other constituents within the organization, and there are some advanced disclosure requirements there as well. So just my last slide to kind of wrap up. The bolded language would just comprise the intended reforms that I would suggest to this rule, and they're all limited to subsection 2. And what they do is they make clear that an individual lawyer can sort of utilize this out, right, and avoid being held to all the rules in the course of their compliance work. And it makes clear what would need to happen here in terms of an informing duty. It involves a writing component so that this is documented as a protective measure for the individual as well. And just kind of in summary, I think these amendments would really just help to manage expectations between the compliance officer and the various persons with whom he or she has conduct. Because as it stands now, I think that a lawyer who has a JD, is not practicing law, but is held to these rules through this Rule 5.7, kind of unknowingly is maybe set up for personal liability concerns, and this would kind of clear up that risk. Because compliance not being a regulated profession, it's overlapping now to a strong degree with a regulated profession, right? And so as I found, this is kind of one of the first pieces of research to talk about this overlap and proposed at least a place to start with how we should regulate going forward. So I'll end there, and I'm happy to take any questions. Yes?
I have a very simplistic question.
Mm-hmm.
How is this compliance officer introduced and explained to the people he or she is working with?
Right. Well, it depends on the organization, of course. And one of the things it depends on too is there a separate compliance department from, say, like the general counsel office?
Assume there's not.
Assume there's not, right. And so sometimes, and often too many times, it's unclear to various constituents that this person is the compliance officer. They might be the general counsel and be have that esteemed position of being sort of GC, they may be known by that, but they also just might be wearing the dual hat of a compliance officer, and it might not be as well known to everyone with whom they're interacting. At least that's been the case in a lot of the smaller entities that I've looked at. It's kind of been unclear that they've taken on that role, unless it's part of their just job description or title. If they already have the designation of the chief compliance officer, it should be clear to various individuals that this is the compliance person. They're not operating in, say, an attorney-client relationship, but many walk away from just interactions with that kind of person thinking everything I just told you is privileged, and we do have an attorney-client relationship, even though you may not. Mm-hmm. So yeah, I think it's very entity-based. Yeah. Yes.
Could you provide just some illustrations of where this might be problematic? I understand that the compliance official does not have the same confidentiality obligations. Are there other concerns, though, where there's just a stark difference between the way a lawyer would behave as a lawyer and a compliance officer would behave?
Mm-hmm. Yeah, I think that in looking at the research on it and just thinking about it as a whole, I think there are some strong inherent differences. Like, for example, a lawyer, it's been found, and whether we agree that this is true or not, in the lawyer position, there may be a little bit of sort of like strategy that's used in terms of how can we insulate the client from potential liability and really protect them. And there might be really a strong desire to keep things as privileged as we can keep them, and not have them just be sort of out in the open, which is actually very inherently different from a compliance officer role. Even if that person is a lawyer by training, but they're operating in the role of a compliance officer, it's not that they owe direct, say, duties of protection in that way to those constituents. It's really to the organization kind of as a whole, but really to the regulator too. So I think just the fact that they have certain reporting duties to the regulatory body changes things a lot with respect to just their interactions with constituents. And it opens up sort of a can of worms even for, in the paper too, I talk about even like, for example, the competency rule, right, of in the professional conduct rules. Lawyers, of course, are required to be competent in their practice area, and if they're not, they would have to call upon others. In most, big settings where you've got like a compliance officer, he or she is having to, work with the regulations at hand. It's more of a risk. They can't sort of call upon the specialist in those regulations in that particular subject where a law firm, might be able to do so. So I think there's various ways that kind of the inherent differences come out and could potentially be problematic.
But the compliance officer presumably is trying to make sure the entity is complying and not getting into trouble. Isn't the first loyalty really to the entity? Because you're not running to the regulators and saying, look, my entity isn't complying. That's not what they do in reality, right?
Well, actually, I think that's been changing in recent years, especially with the development of things like the Yates memo and various DOJ policies now, where there is such a huge benefit to really in advance self-reporting where this is becoming kind of an issue. You know, I think before it was the case that it could just be argued, yeah, the compliance officer, you know, protects the individuals in the organization as a whole, and that's who they care about most. But kind of in doing so now, there are very strong benefits to, even in pretty early stage matters, getting the regulator involved, because a lot of times the regulator can step in and come up with some sort of program or compliance program to better resolve a problem that's on the horizon already. And so I've seen more and more examples of very early self-reporting, you know, that you wouldn't necessarily see if you're just kind of operating in a general counsel role. Not to mention that, you know, the duty of confidentiality would step in there as well. So that's, I think that's changing more and more as regulators and the government become so excessively interested in gaining any and all type of information to kind of work with that individual entity. Yes?
Can you say, excuse me, a little bit about how this would work in those situations where it is the GC wearing two hats, being compliance officer and GC? Is this a conversation by conversation disclosure, or kind of a one-time, you know, explanation, or how would that work?
Sure. So what we do here is, so when we have, you mean with respect to this rule, for example? Yeah. So and there's many examples of people wearing dual hats like that, GC and then simultaneously the chief compliance officer. So my view of those kinds of scenarios is that it's very hard to distinguish between the legal services and the compliance services being rendered. You know, they're being done by the same person out of the same office. And so in that kind of scenario, to me, it is more justifiable and likely that the individual wearing both hats should be held to all of the various ethical rules, which is where subsection 1 comes in my view. Because what this part is saying is that in circumstances where the legal services are not distinct from the law-related services, you're held to all of those various rules. And I think that that's a reasonable argument because, you know, it's very much the case. This is very common in smaller entities too, of course, where people do wear those dual roles. I mean, some have argued that it's a potential conflict of interest too. But in those scenarios, I think it's fair to say that the joint role would have to adhere to all the rules. Mm-hmm. So that's why I hone in more on subsection 2, which in my mind really applies to who the actual significant influx of compliance officers has been. People with a JD who are admitted to the bar, have taken the oath, right? But they're currently in positions where they're not practicing law, yet held to all the ethical rules, possibly, right? So that's where I was going with it. Mm-hmm. Yes?
Question, there's a case, I think it's about a 7-year-old case, I know the first name of the case, Stiftung is a German nonprofit suing a lawyer, and the German nonprofit basically has the assets of a failed corporation that pled guilty to an FCPA, Foreign Corrupt Practices Act, fining, and they paid a fine. The corporation was then sold to another, and they just stand as the foundation that has basically that pot of money in case more needs to be paid because of other things. Then they sued a lawyer in the corporation who gave them what they say it's a malpractice suit, wrongful legal advice, bad advice. The lawyer responds and says, well, the issue in the question was, in the case was, I did not tell you to do the act, to pay that bribe. I only told you that I had retained counsel, foreign counsel, who basically gave me a memo and told me that that payment is legal under the written laws of the foreign country, which is an affirmative defense under the FCPA. I told you that I have no expertise in foreign law, and based on the memo, you know, it was, you know, in accordance with the written law of the foreign country, so you would have an affirmative defense. But my comment in regard to the foreign law, I disclosed to you several times, looking at that number 2 you wrote there with your amendment. And I told you, and I gave you in writing that the service that this guy's providing is not my service, I have no expertise in foreign law, now you're suing me.
Yeah.
So my question is, would this in writing still be enough to overcome, this attack, this lawsuit against the lawyer? Because the client will say, well, I'm looking at you as a lawyer. You gave that to me in writing. I understand that you were saying that you were not an expertise in foreign law. And let's say that the foreign law you hired, law firm, they made a mistake and they misinterpreted their own law. It's not your fault, but I still think you hired the wrong lawyer, or you should have done more. And he said, well, I did what I should have done. I did reasonable research. I knew I had no expertise. I concluded that I should stop. I advised you to retain counsel. You did that.
Right.
My question to you is, to what extent would your amendment help this lawyer
Right.
being sued for malpractice?
Can I just ask, the lawyer who was sued there, they were sued in operating in their attorney role? Or
Yes.
was it, okay, so it wasn't like a compliance officer type of
No,
scenario?
it wasn't. But,
Okay, yeah, so, in that,
but
so
he
this,
wasn't acting as a foreign lawyer at that point. He said,
yeah,
they wrote the memo, here's the memo, they say it's fine with their law. Anything I say about the foreign law is not a legal service I'm providing to you. I have no
Yeah.
expertise. So he does what you're saying there, in writing.
right,
This is not a legal service, I have no expertise, I cannot render you a legal service.
yeah,
All I can say is this, if what he's saying is true,
sure,
you have an affirmative defense, and you would be able to make out an affirmative defense under the statute. But
right,
this opinion, as in terms of whether this is a correct understanding or not, is not legal advice. The
right,
client at this point doesn't care. They're going after you.
yeah.
So would that help that
One
lawyer?
more question, how was it resolved, or was it resolved yet? Was the attorney found to be liable?
Well, the attorney was found to be liable,
Okay.
but because he didn't make that disclosure. I'm
I
just
see.
changing the
Yeah,
hypo
I
in
understand.
the situation.
Okay, and I would love
To
to look
test-
at that case.
to test this modified hypo on your
Sure.
revision.
Yeah, so, no, that's a great way of thinking about it, absolutely. I would respond by saying, I think it's a little bit of a different circumstance here, because this would be an instance where we do not have someone operating in a lawyer role. So, for that reason alone, they're not practicing law, there's not an attorney-client sort of relationship happening, because this is with respect to their non-legal services that they would be providing. So already I think that removes some of the concern, because we're already starting right off the bat with someone in a non-lawyer position, really. So anyway, in looking at kind of the writing disclosure and all of that, I mean, I do think that this is a good way to kind of self-protect and have sort of on file that you have made this clear to the individuals with whom you'd be interacting on kind of a daily basis of your role. They understand in advance that there is no attorney-client relationship here. It's a little bit like upjohn warnings somewhat, that would come about in just other circumstances where you're conducting interviews and you have to tell the person, I represent the organization, not you as an individual. They can, waive that privilege. So I think that in this context, for someone who's in a really like a non-law position, it would be a good protective measure, especially because you have the writing here and you could have it on file to document that you've adhered to this rule. And at a minimum, I think it would protect against disciplinary action by the respective bar to which you're admitted, assuming your state has adopted this rule. Because, California, for example, has not. So, and there's other states that have, 15 states have not. So that's how I would respond to that, but I would be very curious to read that case. I'll plan to look into
I'll
it.
send it to you.
Yeah, that would be great. Okay, yes.
To what extent is this issue a consequence of lawyers and compliance officers having different interests? Right, so a lawyer has an interest in, obligation, hopefully interest in zealously advocating the interests of the
Yeah.
client.
Yeah.
In the compliance context, the lawyer's interest is not necessarily to comply, but to keep the company out of trouble, which might not be the same thing. Right? I mean, we all know the lawyers that tell clients not to put things in writing or not to ask certain questions or what have you.
Right.
Not to disclose past conduct if it's not going to be protected, whereas a compliance officer might have slightly different interests. Indeed, I'm
Yeah.
wondering if because you said something about the compliance officer might have interests aligned with the regulatory agency, and in the extreme case, the more demanding compliance is, the more valuable the compliance officer's services are.
Right.
Which would suggest that a compliance officer has at least some interest in the maintenance of a costly, hard to comply with regulatory regime, whereas the general counsel and others who work for the company might have an interest in a less costly regulatory regime, at least insofar as the company's interests are concerned.
Right. Yeah, definitely. And I think, in just talking to other sort of compliance scholars and things that other people thinking about these things, I think the consensus really has come out that the compliance officer, him or herself, is kind of a representative of the regulator, really. Yeah, as opposed to just representing for the benefit of that whole organization, right? And so, because if they don't possibly report certain things in a preemptive manner, they could face potential liability. And then there's been a whole slew of sanctions, rendered against just compliance officers as a whole, from FINRA and the SEC for being complicit in violations. So I do think it's definitely beneficial if the person coming in has very strong industry knowledge and experience, and maybe has worked for the regulatory agency beforehand as well, to gain that. I think that would be every company's ideal compliance officer, because you really have an expert kind of coming in that has a good relationship with the regulator already, and sort of knows the ins and outs of how to really correctly navigate the system. And it's just, I think, goes back to inherent differences with the interests of a general counsel, still can be said to be really zealous advocate for the organization, I think, as a whole. That would be there's a separate legal person to whom they owe their interests. So I think that the two, are pretty different in terms of their inherent interests. So I think it could be problematic then if you have someone wearing the dual hat role. They just have to be, I think, more cognizant of all of these different competing interests at play. Because some of those people have been sanctioned and penalized for sort of proceeding on with conflicts. Mm-hmm. Yes?
So, I'm always interested in proposals that talk about using some kind of an information mechanism to solve what potentially could be a conflict. Mm-hmm. And I think this absolutely provides certainty on the attorney's side. And
right.